Hey class, it's Mr. Stewart, and this is the Week 11 Integrity Lecture for CRJ 130. This week we're going to be talking briefly. This is not going to be a very long integrity class this week because this chapter is very straightforward. What we're going to be talking about is how civil cases end. This is kind of the tail end of our series on trials. We talked about criminal trial, we've talked about civil cases, how civil trials begin. Now we need to know how they end. The first thing I want you to understand is that when we're talking about procedural law is basically how a case moves through the system, whichever system it is, whether it's the criminal system or the civil system. But we have something called procedural law that really governs how that case moves through that system. Understand that, and you should already know this, that civil cases are much different than criminal cases, and as such, so are their procedures. Now, they're similar to each other, but we do use some different terminology, and there's definitely different quantums or levels of proof required to win either type of case. So on page 323 in your text, make sure that you read that section on civil procedures. There's also a table on page 325 I want to call your attention to. These are the steps of civil procedure. I'm just going to go through these very quickly. First of all, there's a complaint made, and that is the legal terminology for when you have a grievance against somebody and you actually file a lawsuit against them. You file a complaint. Once the complaint has been filed, then that complaint must be served on all parties, and we're talking about that it must be served on whoever it is that you're suing, they're filing the lawsuit against. That's the complaint, or excuse me, that's the service step. After all parties involved in the civil process have been served, in many cases they ask the other party to file an answer. Basically, answer this lawsuit. Because we're making a complaint, we're making a claim, you've been served with it, now you know that we've made a complaint, now answer it. That's really what an answer is. It's a defendant's response to the allegations made by the plaintiff. Once an answer has been made, then that kind of gives both parties the opportunity to see who's holding the cards and to see what each other side has got. And then we also get more information from either side through the process of discovery, and that is the process by which parties to a lawsuit exchange information about the case. Now, not every piece of information is allowed to be disclosed through discovery, but basically it allows each side to know what the other side has, and it lets them to help make a decision as to whether or not we need to continue on with this case, we need to try to reach a settlement, or this case is just completely bogus, whatever. Once discovery has happened, both sides have kind of given each other a certain amount of information from their part of the case, then you go through motions. And these are requests that the judge make a ruling. Maybe one side makes a motion that either should have a piece of evidence admitted or you should have a piece of evidence excluded from the case, or maybe they try to get a particular witness excluded for whatever reason, and all that is done by a motion is simply a question asked of the court in which the judge must make a decision, make a ruling, and this is all before this thing goes to trial. After all the motions have been made, then you have pretrial conferences, and the judge may require lawyers for all parties to meet and just to make sure your schedules line up, when we're going to try to set a trial date. Is there anything that can be done to resolve this case without going to trial, etc. If there is, then we go through the settlement phase. We don't necessarily go to trial at that point. We reach a settlement. The judge has to approve the settlement. Both sides have to approve the settlement, and then if that's accepted, then the case is theoretically over at that point. If no settlement can be reached, that's when you go to trial, and that is the fact-finding process to see which particular side is right. And whatever the judge decides after the trial, there must be a judgment entered, and that judgment is enforced, and that's collecting the money, damages owed to the defendant, or possibly even the plaintiff if there's a countersuit that has been filed. So, in a nutshell, those are the steps of civil procedure. Every single civil case will follow those same steps. And most of the time they don't necessarily skip steps. They just move to that step, and if there's nothing that can be done during that step, then they move on to the next one. So make sure that you read over that section starting on page 325 in your textbook, and it goes through the complaint, the service, the answer, discovery, motions, pretrial conference, trial, and enforcing judgments. It gives you a little bit more information about all of those. It's really straightforward. It just kind of tells you how the case will go. Understand that most civil cases are settled via negotiation, and that means that we don't necessarily go to trial on them. That we reach a mutually agreeable verdict or mutually agreeable settlement through negotiation. Both sides talk to each other, they iron out their differences, and then finally they reach an agreement as to here's how this case will end. Most civil cases end that way. Starting on 332 in your textbook, it talks about the types of negotiations. These are also really straightforward. So best result negotiations, appropriate result negotiations, and ritualistic negotiations. I'll read through those. If you have any questions on those, please reach out. Looking through the rest of this chapter, understand that, and I told you this last week, there's basically two levels of civil court. There's what we would consider to be small claims court. That's a majority of those cases. That they're not asking for a huge amount of money. They just feel like somebody's been wronged by another person or an entity, and they're just trying to recoup whatever their damages are. And then you also have the more complex civil cases, which that's when you're seeking huge amounts of money damages or punitive damages because somebody's been wronged, or a whole group of people have been wronged by a person or a whole other group of people. So a lot of times that those also end in settlements. And I can tell you from personal experience, I was part of a class action lawsuit against a government agency several years ago because they had created an unsafe work environment, an unhealthy work environment due to some problems with a building. And we actually asked the agency head to fix the issue first before we ever sued. And basically the agency head said, there's no problem here. You're all traitors if you're even asking me to fix this. So we sued the agency head, the assistant agency head, the political subdivision, and for $200 million. And there's about 30 of us on this lawsuit. And we settled it. It went on for about a year or so. We settled the lawsuit for something less than $200 million. But I can tell you that from my own personal experience, the law firm that handled all of that casework for us pocketed about 60% of the settlement because they were working on something called contingency, and that means that they didn't get paid up front. They only got paid if they won. So it was considered a win if we reached a settlement, and the way it worked out, I think about each one of us got somewhere in the neighborhood between $5,000 to $20,000 settlement, depending upon the nature of the harm that had been caused to us through the unsafe, unhealthy work environment. And of course, the attorneys pocketed several $1 million. Of course, they had some expenses. I understand that. But when we're talking about torts and civil cases, it's just amazing to me how much money the attorneys actually make and how little money the clients usually get, even if they win their lawsuits. So, you're almost better off to file a small claim suit and incur very little legal expense than to go with one of these complex cases, because even if you get a huge judgment, the attorneys that get it for you are going to pocket probably half, if not more than half of it, and then you're going to get something, may not be a lot, and then even in some cases you may not get anything, because all the people have to do is file bankruptcy and say there's no way we can pay this judgment, so we're just going to file bankruptcy, and you don't get anything. So just understand that with some of these larger, complex civil cases, the only people that really most of the time come out ahead are the attorneys, and unfortunately, most attorneys probably wouldn't necessarily agree with that, but I think that I think, in my own personal opinion, in my own personal experience, that has been the case. Also, in this chapter, it goes over about 4 or 5 pages of how divorce cases are bargained. Some of you may have been through that. Some of your parents may have been through that. Read that section over. It's also pretty straightforward. And if you have any questions, reach out. This chapter was not very long. Did not have a huge amount of information, but it did give you some very useful information as to how a civil case goes through the system. So if anybody has any questions, make sure you reach out. And I have at this point caught up with responding in discussion boards and grading. So if anybody has any problems, questions, or concerns, make sure you let me know, and I'll be happy to help you. Have a good week, guys. I'll see you next week. Bye bye.